once again. Thank you all for joining us. This is Nuance. I'm Mike Scala, joined as always by Jay Carter, also known as Timid, the hip hop artist and chair of BLM Tokyo. What's going on, Jay?
Just getting ready for this conversation here. It's been a crazy week all the way around.
It's gonna be a heavy one.
Yeah, I think the country's regressing, but we'll get into that.
Mm-hmm. On this Independence Day, right? I think we should ask ourselves, how free are we really today?
Yeah, right.
So we are joined by a very special guest. We've got digital marketer and former community organizer, Kirshan Murphy. What's going on, Kirshan? KJ, as we call you.
Yeah, exactly. Doing good. Life has been life in the past few days, but then we're all in the country, man. It just like what Jaylon said about regressing. There's a lot I talk about that. I talk a lot for over the years about periods of punishment this country has gone through, and I think we're in one right now. And I'll talk more about that.
Yeah, absolutely. There's been a lot of fireworks out here today, so while I'm speaking, you might hear the boom boom in the background. It's not gunshots, it's fireworks. So keep that in mind. We'd like to start off on the light side. I don't know if we really had anything too light. As we mentioned, it's really been a heavy kind of week here. I've been in album mixing mode, so there's that. I know we've talked about that before. I've kind of been burying my head in that. You develop these dog ears, as I call them, after listening to the song so many times. You start to hear things that no one else could possibly hear, and then you drive yourself crazy a little bit, but you just also feel like you have a bit of a superpower, right? It's like, I can hear everything, and then you listen to other songs, and you start hearing them in a whole different way, also because you're in this super mixing mode. So that's kind of cool.
Yeah, mixing is a beast, especially when you got a bunch of different tracks and trying to make them all balance out. It's just it takes a certain type of person.
That's the big challenge, right? Because you've got different tracks, and in my particular case, I tried to have tracks that were different enough to not sound like every track is the same, but also that were cohesive, that work together to make it sound like the same project, not some random compilation or mixtape. And it's hard to find that balance, especially when you're mixing, because you want them to, again, sound different, but also cohesive. So it's like the same, but different at the same time. It's kind of hard to find that balance sometimes, and you do drive yourself crazy. Get those subtleties right. Yeah,
absolutely. And that's when I just send the session to you.
Even more stressed out. Well, luckily I've been able to clear the calendar for the most part. I do have some cases coming back up in the next few weeks, but things slow down a bit around this time of year anyway, and I was able to clear the calendar to the extent possible to focus on getting these mixes done. So I'm excited about that. They're passing the car test now, which is good, right? When you first start out, it's like they're in your native system, whatever studio setup you're using, maybe monitors or what have you. You check them out in headphones, then you start taking them to other places. It's like, all right, they're good in the headphones, they're good in the earbuds, they're good in the laptop. Now they're getting good in the car. So it's exciting to finally be turning that corner and be like, all right, I'm getting very close now to the mastering phase.
Yeah. So I did want to send like Kay just said, it's been a heavy week all the way around. We lost an uncle yesterday.
Yep.
He used to sometimes listen to the show as well. So
wow, my condolences on that. I didn't know about that. Wow. Well, I guess we should get into it then, because we do have a lot to cover here on this. We've got the 2 Supreme Court cases I know we wanted to mention, at least 2, right?
Right.
And there was the city budget as well. Not a whole lot of exciting information to come out of that. I guess we could even start off with that to get that out the way, because it is a $107 billion budget deal, the largest in New York City history. But as of now, there aren't too many headlines coming out of it, right? In spite of it being the biggest budget in city history, you are seeing cuts across the board, and that became a source of controversy. You had progressive groups in particular urging council members to vote against it because of the cuts. And in fact, if you look at the final breakdown of votes, it was mostly the the progressive wing of the city council to vote no. I think only one Republican voted no. Most of the more moderate members voted yes. But one thing to keep an eye on here is the mayor is saying that no schools will be cut. Remember last year, that was a big point of contention. Jay, we had Paul Trust on here who actually sued the city over that.
Yep.
So they're saying that no individual schools will be cut, but there's some questions over that because he's saying that the mayor says that there's no desire to cut schools in the middle of the year. So it's saying no school will be cut to begin the academic year, but there are cuts in the middle of the year, mid-year budget updates, and there's no desire to cut them in the middle of the year. So we'll have to keep an eye on that. And I think in this current election cycle, you saw some council members criticized for voting for the budget last year, which did cut education. And they were trying to say that individual schools were not cut. To some, it seemed like they were playing a bit of a word game there. So again, we have to see that. I mean, there are teachers who definitely suffered from these cuts last year. And I think that's why some of these groups are pushing back now. They don't want to see people losing their jobs and the people of New York suffering.
Right. Absolutely. You said this is a $107 billion budget? Jesus.
Yeah, $107 billion.
Let me get a little bit. Let me hold something.
Yeah, and it's kind of hard to fathom how it's the biggest budget in city history, and yet cuts to spending are being made across the board. Right. Those things are happening at the same time. So you think with all this money, why are we cutting all these things?
Well, it means that they're putting more money into other areas. So the question is always when there's cuts is what are they cutting? So it seems like they did not restore any library funds if I'm looking at it correctly.
No, they did. They restored $36.2 million to libraries.
Later restored. Okay, yeah, right. There was some funding for city-supported lawyers. It was increased, but not to the requested level.
Right.
So, yeah, you always got to look at what they're cutting, and what they're adding to. Like, who got extra money and why?
81,000 people, it says, were asylum seekers city helped care for, which cost billions of dollars alone. So that's a big part of the budget.
Right. And that's kind of what we were talking about on a previous show, right? When New York was discussing whether or not to give the health care to undocumented folks.
Right. But this isn't that. I mean, that would come through the state. This is just carrying asylum seekers through the city, right? This is the city budget.
Right.
I think we also mentioned this on the show, the CUNY cuts, right? The mayor was proposing, I think, a $41 million cut to the City University of New York.
Right.
This budget restores $32.4 million to that budget. So it doesn't get you all the way there, but it significantly makes up those proposed cuts. So unfortunately, the headlines and the articles that I'm seeing really focus more on the restorations.
Right.
Right. Like not so much the cuts, but where the money was put back. I'm not seeing a whole lot in terms of itemizing where the cuts are, but everything I'm seeing shows that there have been cuts across the board, which I guess is why you're not seeing that itemization. They're basically saying everything was cut. But again, it's kind of hard to reconcile that. Why is it the biggest budget we've ever had in history if everything is being cut?
Yeah, right. It's like you have such a large budget for such a large city, literally a city that has the largest school system in the country too.
Yeah.
And they're talking about, oh, this is the biggest budget, but there's also cuts. And especially when you start looking at the education system, you really want to look at like what exactly is going to be cut there, because you're talking about, I don't know what it is, correct me if I'm wrong, but I remember it was something like almost 1 million students in the New York City system, but it's so that's a huge thing. That's no small thing if you start talking about cutting from specifically education in the New York City system.
Yeah. Right. And then you see tuition hikes at the city schools as well.
Exactly.
Yeah, that's
78% of city employees now working under new labor agreements. The city has settled labor deals over the past few months. The increased pay and benefits included have been a major source of new costs, $16 billion over the next 4 years. So I guess that's where you're seeing the cost, right? You're seeing some of these expenses and you have inflation and you just have things be more expensive now. New York City is known for being a very expensive city, right? So in spite of cuts, you are seeing it's costing increasingly more money every year to take care of our people.
And, it's already having issues, as we've talked about before, as far as what's going on in Manhattan regarding like empty buildings and stuff because of the costs and because of, lasting effects of what happened during COVID. And then I think it's going to get a little bit worse because there was remember, we did talk about before about the congestion pricing, which seems to have gone through. So that's going to make it more expensive even just to get in and around Manhattan. Was already facing some issues. So I think they're going to have some stuff to deal with.
$95 million to fund the expanded eligibility of the Fair Fares program, which provides half-price Metro cards to low-income New Yorkers. So you are seeing new programs created and existing programs expanded, which is accounting for some of this increase. But you're also seeing cuts, right? So again, I think it's something we just need to keep an eye on. And when they say things like no school will be affected by this, well, we'll have to hold them accountable on that and make sure that's actually the case.
I'd be interested in looking at, I don't know if we're move on, but I know I'd be interested in looking at too, as far as housing, because what Jay just mentioned about, empty buildings and stuff like that. Back in my community organizing days, there were times I'd go into these buildings that had absentee landlords and folks were kind of fending for themselves. And I remember there was a building I was trying to organize for, and some of the people in there had no hot water. So they were trying to warm up hot water on the stove to be able to bathe, and that's when you start looking at the New York Housing Authority and kind of for help, and I'm just wondering what kind of resources they have nowadays. And of course, I'm talking many years ago when I was doing that, but I think that's something that's an important institution in New York, especially just from my own experiences as a New Yorker.
Sure.
Looking for places, but then also as a community organizer and helping community members to organize in their buildings, to organize around getting positive change to happen inside of their building when needs were not being met, So it's very interesting.
Yeah. Well, this budget allocates $4 billion in capital funding for affordable housing, and that's up from $2.2 billion this past year. So almost double the affordable housing budget.
That's good. That's good.
So
it always I don't know. It's always funny to me what some people would consider, and usually in these budgets or in these discussions, what they would consider affordable housing.
Oh, that's a whole different discussion, right?
Yeah, yeah, right. About it's $4,000 a month. This is affordable housing,
right? No, I've talked about this a lot. They've used the area median income, but the area includes counties outside of New York City. It goes into Westchester, Nassau, Suffolk. It's not really an area. It's like the entire region of the country.
Yeah,
it's ridiculous.
Right. Yeah. So,
we'll move on. Like we said, we may have to revisit this conversation to see how some of this plays out. Right. One thing I would say, just to wrap up on this, is the mayor and the speaker of the council shake hands over the budget. It's a kind of a tradition in New York City, and Councilmember Charles Barron made the statement that it was the least firm handshake he's ever seen. He thinks the speaker only gave him 3 fingers.
Interesting.
Yeah.
Taken out of context, that could sound very
But you know what? The politics of it is interesting because really you had all of these progressive groups putting pressure on all of the council members to vote against the budget. And then you saw the more progressive council members who really relied on that political support voted no. Then you had the more moderate ones who still kind of wanted to be seen as progressive, but they would vote yes, but they would hedge a little bit. So the speaker, I think, falls under that category. She's like, I'm going to vote for this, but I'm going to make a statement about how I don't really love what I'm doing. I think she even said this was a very difficult budget to pass. We had to do it, but I'm not really happy about it. So you do see those politics play out.
True. The city council, I don't know if y'all talked about it, but Youssef Salom.
Yeah. Oh, yeah, that's right. That's a big story. Probably the biggest story coming out of this election cycle because it's kind of a slow year in general, but that's a big one. Central Park 5.
Yep.
Yeah.
Exactly. Yeah. You had the guy who won a Central Park 5 who Trump literally called for their executions back in the 80s.
That's right. Took an ad out. What was it? New York Times?
New York Times. He took a full ad to make the case for executing all of them.
Bringing back.
And they were children.
Yeah.
And they were children at the time.
Yeah, they were kids.
Yeah. And when they were exonerated, he refused to walk back his position.
Right.
Yeah.
To this day, he thinks they should have still been executed. To this day, he thinks that.
Yeah.
No. So it's really awesome to see that, out of that from that one end of what happened in the 80s up until now, him becoming a member of the city council. That'd be really cool to see kind of what happened.
And that's good progress.
Yeah.
Right?
Yeah.
Also, want to shout out Chris Banks, whom I know personally. He won his primary. He actually beat Charles Barron, who I also like, by the way. But congratulations to him. He'll be taking his seat in the city council next year to represent East New York, which is the neighboring district from here. So it is good to have people you know and you can work with in office. It's always good. People that you think will do a good job.
Absolutely.
So, all right. We talked about that being progress. You know, a lot of times if you feel like, or you see maybe one step forward, two steps back, or in this case, maybe 3, 4, 5, 6 more steps back. The Supreme Court decision. And like we said, there's actually more than one, but the major one was on affirmative action. That was the big one that I took notes on. Students for Fair Admissions via Harvard and UNC, 237 pages. It was the majority decision led by Roberts, and then you had a concurring decision, which we'll talk about, from Thomas, and you had 2 dissents. You had Sotomayor and Jackson with their own dissent. Yeah, and actually, we'll talk about this more. This was the first time since 2019 where dissents were read from the bench at the Supreme Court, showing kind of the gravity of the moment. They actually read their dissents out loud.
Mm-hmm.
Yeah, so, that was the chance for Jackson and Thomas to kind of go at each other.
Oh, yeah. And Thomas, again, we'll go into more detail on that. Thomas, once again, is more conservative than the conservative majority.
Right.
So,
right.
For those who don't know, this was about affirmative action when it comes to college admissions. And of course, Harvard and UNC were the 2 colleges in this particular case, but it extends beyond those 2. It's about college admissions, generally speaking. And the argument by this group of plaintiffs called Students for Fair Admissions, they were a nonprofit group organized just to fight this one issue. Their argument was that affirmative action was not constitutional. They said it was a violation of the Equal Protection Clause of the 14th Amendment. And that's really what this case is all about from a constitutional point of view, whether the Equal Protection Clause allows race to be considered as a factor in college admissions. Of course, we know the court decided
right.
The answer is no,
and
we cannot consider race anymore.
Let's not, did he freeze or did I freeze?
I don't think we're frozen.
Oh, I don't know. You had a frozen face there for a second. It was like, yeah, like you were in pain or something. I think it's me. My connection seems to be unstable. Yeah, and that group that you mentioned, Students for Fair Admissions, is actually bankrolled by a man named Blum, who's in the background. And so we'll get into that. And it's also important to notice how Asian Americans are being played against other folks in this fight. And to be fair, the people participating are actively participating in it. So, you know, they don't get off on that either.
Right.
Well, the majority opinion starts off by talking about Plessy v. Ferguson and Brown v. Board of Education. And this is the kind of thing that they did in that abortion decision that we talked about. They like going into the historical context, not of the issue so much, but of the Supreme Court jurisprudence. And they make themselves seem like they're fighters for civil rights somehow. Like they try to act like they have the high ground on this, right? Like Brown v. Board of Education, we decided that you couldn't have discrimination in public schools. And now we're saying that you can't do it in colleges. They're acting like this is another landmark case for the side of civil rights, which is very odd and quite frankly, ignorant, but they've done that multiple times now.
Absolutely. That's a typical conservative talking point, is they try and twist the words around. One, like you mentioned, those landmark cases, Plessy versus Ferguson, Brown v. Board of Education, and even MLK himself. That's probably the one they do all the time. And I've even seen since this ruling came down, people saying, "Oh yeah, well, it's good they did this because MLK said content of your character, over," and that's what they use in the comments online and that sort of thing. And it's a total distortion
Right. And I think you hit on it there. That's really the whole fundamental argument from a philosophical point of view, right? The conservative way of thinking about this and the more, I don't even want to call it progressive, but I would say the common sense way of thinking about it, or the more accurate way, not to sound too biased, but I think that the conservative way of thinking about it, for lack of a better phrase, is that all of this kind of happens in a vacuum and you don't put the real historical context into it. You don't look at what's going on historically or in society. You just look at it like we're all already inherently equal, and therefore anything you do is going to disrupt that equilibrium. But it's a very naive, ignorant, and privileged way of approaching the situation that isn't really in line with what reality is.
Right. Yeah. It's a self-serving way of approaching it.
Yeah,
they know exactly what they're doing, and they're using distorting the words on purpose to do that. And you mentioned that MLK statement. That's one of their favorites. Absolutely. To throw out there.
Yep. And you mentioned, Mike, the context, like throwing out context.
Yeah.
And that's literally what they're trying to do with the whole critical race theory thing.
Sure.
Into the schools and throwing out these books, saying you can't talk about certain things from history and some of that, especially things that tie into this. That would actually provide the context of why affirmative action is needed in college admissions. Like we have HBCUs in this country because African Americans just were not allowed to go to college at these institutions.
Right.
And so
and a lot of that comes up in the dissent. The majority opinion doesn't want to acknowledge any of that, right?
Right. And they don't want to acknowledge that it's still in play today, that these things still happen today. And absolutely, it's easier to get into college for, Black Americans and non-white Americans than it was previously today, even if there's not affirmative action. It's definitely easier, but that doesn't cover everything. That doesn't make it the equitable situation that's needed, because there's still this discrimination that takes place. And we see it in not only in college admissions, but we're seeing it in different places. It comes up in the news constantly about, even real estate appraisals or job situations where two candidates could be one white, one black with the exact same qualifications, exact same history and experience, exact same age. And more often than not, they're going to choose the white candidate over the black candidate. It's just part of where the country is, and we have to acknowledge that so that we can make things more equitable.
Yeah, exactly. And it's like, affirmative action is one of those things to help things become more equitable, help give African Americans a chance, and it's so interesting because, Clarence Thomas, he praised affirmative action decades ago when he was admitted, I think it was into Yale Law School, I think it was, where Clarence Thomas, I might be wrong. But he praised it back then. And then, even at some point under Reagan appointed him to be the head of the Equal Employment Opportunity, EEOC, and he's like, that was his role, was to help make sure the places of employment, are equal as far as from a race standpoint.
Right.
And then he goes into the Supreme Court, and here we are decades later, and with this ruling, he helps to literally tear down the ladder that he climbed.
Yeah.
They helped him up to where he is.
Right. And now he's advocating to actually go even further than what he himself advocated for since being on the Supreme Court. He even says that in his concurrence that, 20 years ago, I thought that we should have some kind of affirmative action. Now I think we should have none. So he's going even more and more extreme as time goes on.
Exactly.
So, and I want to talk about that. They bring up right away this case called Grutter from 2003, where the Supreme Court said that racial quotas were not allowed in college admissions, but race could be a factor, right? And there is something in there that says that they hoped in 25 years that would no longer be necessary to achieve equality. Now, obviously, that was not the law. That was something they put in their decision. We know these decisions are very long. They say a lot of things. Not everything they put in the decision is the holding of the case, is the actual law or the constitutional analysis. A lot of it is what we call dicta, like just kind of points that are just made. And they might be interesting to look at to kind of give you an idea as to what justices are thinking and what have you, but they're not the actual law. Right. The majority here seems to treat it as if it is almost like the law, where they make a big deal of this. In 25 years, they said it should no longer be necessary. That was 20 years ago. I mean, it's not like a sunset provision, right? It's not like Congress passes a law and says this will only be good for the next 20, 25 years. That wasn't the case at all, but that's kind of how they're taking it. Let's keep in mind that this is only 20 years ago, and they aspirationally said 20 years ago, we hope in 25 years, we hope in the quarter century, it won't be necessary to look at race anymore. But obviously in 2003, they wouldn't have known where we would be as a society in 2023. They were being optimistic about that. That's not a reason now, less than 25 years later, to say, well, because they said that 20 years ago, we can undo all this now. So
yeah, I mean, we're 60 years from, the Civil Rights Act, and it's, that 20 years was passed multiple times, 3 times over. So it's like, it's 20 years is not enough time to undo the hundreds of years prior and the continued mentality of the people that still have these beliefs and still follow these practices.
Right.
Yeah.
So let's get into the constitutional analysis here a little bit, because like I said, it's the equal protection clause of the 14th Amendment that says that everyone is entitled to equal protection under the law. But the Supreme Court has always considered any attempts to discriminate or favor race, and any race-based discrimination of any variety, they've considered that having to meet a strict scrutiny standard, where it's presumptively unconstitutional, but it can be allowed under narrow circumstances when 2 factors are met. Number one, there needs to be a compelling governmental interest that the state must articulate. And number 2, it must be narrowly tailored to meet that interest, meaning it needs to be the least restrictive way of meeting that goal. So it's a pretty tough standard, but it can be met. In that Grutter case, for example, they decided that it was met under those circumstances. Not to have a quota, but you can have that factor. You can consider race one of the factors in admissions to meet the compelling government interest of having a more diverse student population. So right away, the court here is saying that neither of those 2 factors is met. They're saying that there's no compelling interest. They instead say it's a commendable goal. And here's where I actually, in my notes, I asked whether this was argued the wrong way. I'm not sure if the argument here was poor or if the court just disregarded the good arguments and tried to twist it to the outcome that they wanted. I would have to go into more detail on actually looking at the briefs and actually looking at the arguments more. But what they're saying is, in order to meet that compelling governmental interest prong of the test, the schools, and we should make the distinction between UNC, which is a state school, right, and Harvard, which is a private school. So in order to have the constitutional analysis, you have, I guess that's UNC's case. The Harvard case would fall more into the Civil Rights Act because that's private, but nonetheless, this is the analysis that they're using. So what they're saying is that the compelling interest here, as cited by the respondents, the schools, were training future leaders, acquiring new knowledge based on diverse outlooks, and promoting a marketplace of ideas. The court is saying those are commendable goals, but they're not compelling interests. My question is, why would you even argue training future leaders and a marketplace of ideas? Those do sound a little bit vague and not strong enough. If you're trying to meet this very difficult, compelling interest standard, why not argue the compelling interest is combating systemic racism and ensuring fairness in admissions, making sure there's no racial discrimination? That's really the compelling interest to me, because if you're describing that just as training new leaders and things like that, you are kind of leaving yourself vulnerable to be attacked this way by the other lawyers and by the court. I
agree. If that was the argument, then I think that would be a very weak argument. Because I'll even go further. I totally agree with what you said, Mike. And I would say even argue the economical impact. If you want to really see how race impacts this country, look at the economics of it, how it impacts earnings, it impacts home ownership, right. The amount of minorities in the country who own, just say specifically African Americans who own homes is very low. And you could make an argument, a counter argument to the conservatives who try and say, oh, we need to pull ourselves up by our bootstraps. Well, that's what we're trying to do, and part of the going the pathway to being able to earn more money, to be more economically stable, and part of it is home ownership. And being able to go to college, being able to get into college, get a good degree, and be able to get a job is part of that. And if you have all these different systems in place, that's part of the systemic racism in this country that helps, that has barriers in place for us to do that. It makes it harder, And so it's like that argument itself would be a more compelling one. You take that, go from the economic standpoint. It's about the money. It's like when I was at Florida State and I was a political science student. I think one of my first classes, my professor asked, like, what do you guys think politics is? And then people were trying to throw out their own answers and stuff like that. And he was like, oh, ultimately politics is who gets what and when, and that's what it boils down to. It's like that's what politics is. And that's what all these different systems in place were put in place historically to prevent certain segments of the society to be able to reap the benefits of what they call the American dream. We don't have the same access to that American dream. We're trying to have access to it. And affirmative action was one way that allowed us to. And so, they want to take that away, then it's going to make it harder. They think it's going to help. They think it's from a philosophical standpoint, it makes admissions fair, but it doesn't. It really doesn't. And this just goes to show, it's a reminder of how important HBCUs are. And at the same time, it even makes them even more important again. But
I think I think it's, I don't know, hopeful maybe to think that they think this is going to help. I think they know exactly what they're doing. I think they know exactly that this is going to disenfranchise folks, and they don't care because they want the outcome that they've wanted since affirmative action was put into place, right? Since their ancestors were enacting the actions that were made affirmative action necessary. Exactly. Like this is an extension of that same mentality, and they've been fighting to get rid of it for a long time. And yeah, I can't give them any allowances that they're misguided in this way. They're purposefully manipulating it. And that question comes up when you look at what was the organization, America's First, not America's First, the Student for Fair Admissions, right? This group is being backed by, I believe it's Edward Blum, this conservative that's pushing this agenda. However, the face of this and the face of that lawsuits, and who's been kind of recently on the front lines of this fight to get rid of affirmative action, are Asian Americans who are complaining that they're getting passed over for admissions to these higher schools because of affirmative action requirements for Black and Brown students. When, first of all, their admissions in these schools are higher, are higher, almost to the level or higher than some white students. They're some of the highest admissions percentage-wise in these schools, so they're not getting passed over for anything. Right? There's a couple of mediocre students who are unhappy that they didn't get in, and now they're trying to attack the systems that made it fair, that they stand on the backs of, because they couldn't get into college before the fights that brought about things like civil rights acts, things like affirmative action. And so this is where the position is. And so they say, oh, well, it's not, Students for Fair Admission is not an Asian American organization. But you go to the website, every picture on the page there is all Asian Americans. Like, this is who's heading the fight on this. But it's being pushed by Blum in the background.
Let me ask you, Jay, because this comes up in the case a little bit also. Is it, I mean, I think I know the answer, but you say you go on the website and you see Asian Americans on almost every page. Is it mostly East Asian, South Asian, or a mix of both?
It look well. You can't really tell for sure, but I think it was East Asian, maybe.
Right.
Yeah.
Okay.
Which would play a little bit into colorism.
Yeah.
Right. But on that point, I would say, those students participating in there, they don't completely get free of blame, even though you can say that their strings are being pulled by Blum, because they still have to have that anti-Blackness and that discriminatory sentiment themselves to actually push towards this and participate in it. But, they may feel that they're being discriminated against, but they're really not. Like I said, they're overrepresented as far as the size of their population.
They're overrepresented, but I believe that there's a thought that without affirmative action, even more would be able to get in than now.
Well, yeah, they're saying that there's a group that's saying that I can't get in because affirmative action has taken away some spots that I should have gotten because you look at my academic record or whatever. And in a lot of cases, sometimes not a lot of cases, some of these cases, you look at these people's academic record and they didn't have the academics to get in. They're just disgruntled. This was the case with Mindy Kaling's brother, the actress Mindy Kaling.
Right.
Her brother tried to get into school, couldn't get into these certain schools that he wanted to get into, and he pretended to be black to get into the school because he had dark skin. He shaved his head. He called himself Jamal, and he got in as an affirmative action student, pretending to be African American for his time in the school. Yeah. But he didn't have the academics to go to the schools that he wanted. But he tried to use this loophole and take someone else's spot to do it.
I remember when I was applying for law school, they made a big deal about, are you an underrepresented minority? And that was really targeting Asian Americans, right? Because Asian Americans would say, well, we're minorities, we should get this boost as well. But they said, well, no, there are already too many Asian Americans in higher education. So we want underrepresented minorities. And so being an Asian American was actually a strike against you when you were applying for law school.
Right. And so some are feeling that as a discrimination against them. And you're using black and brown folks as the reasoning why.
Yeah, I want to talk about that when we get to it, because they actually use the term zero-sum game. And that's also something you see, I think, philosophically between conservatives and others about basically if you're benefiting one group of people, in their mind, that means that you're hurting them. And right. I think that the better way to look at it is you're actually helping everyone. But let's get to that when we get to it, because I've got a lot of notes on this opinion here. The next thing the court starts talking about is they say that the admissions process falsely assumes everyone of a certain race thinks alike. And they're really attacking this diversity of ideas, marketplace of ideas argument, which again made me wonder if this was argued the wrong way, because it is easy to argue that, if you're saying that the compelling interest here, why we think this should be upheld is because we want a diversity of ideas. It is easy for the court to say, well, aren't you just assuming that everyone of a certain race thinks the same way? Or why are you assuming that you're getting a diversity of ideas just by admitting people of a certain race? So again, I don't think that was the right focus. Now, to be fair, I think the court probably chose to focus on those. They're picking apart the weaker points of it, right?
Right.
I don't think just saying we want a diversity of ideas is the best approach if you're arguing this.
I agree. It goes back to the point I was making earlier.
Yeah.
Should have gone the economics route.
Yeah.
That's the big thing of what race has impact on in this country. It really is the economics of how we are able to live. Even the justice system, it's economics. Yeah. The majority of people who are arrested and put in jail for marijuana use are African Americans, but we're only like 12% of the people who use drugs in this country. But almost 50% of people in jail for marijuana is African American. But then you get out. And what can you do when it comes to trying to get a job and provide for your family? It impacts the economics. Race has always been about power and money. It's about back from slavery. It was trying to make as much money for the South as possible without paying for the labor. And even now, one thing about the affirmative action, this ruling, it didn't say anything about not allowing colleges to consider gender. It didn't say they weren't allowed to use legacy admissions for just because your parent went to the school. They said that's not allowed.
Yeah,
they didn't say that shouldn't be allowed. But they said,
and they even left the door open for some other things, which we'll get into concerning race, even. So I think it is narrow, but the court does generally have to issue a narrow decision just based on what's before it, right? So that goes back to the case that was brought and the group that brought that case. They weren't focusing on those other factors. They were just focusing on race.
Right. And I think, a lot of people are bringing up this idea about legacy admissions, and it's a really good point, because those spots are also held for legacy folks. So that means people who are who want this merit-based admissions process should be looking at that and be like, well, I couldn't get in because that spot was held for his son or his daughter. So that's another thing that should be considered. Now, I've seen on the internet, and I thought it was a good idea, and I might want to get you guys' thoughts on it. And in regards to that, people are saying, okay, well, and I think there was a group that filed a civil rights complaint in this regard after this ruling, to say that just in the same way the Harvard lawsuit was brought forth, to say that the legacy admissions is unfair and unjust. So in the same way, saying that, it's unfair for the admissions for this to be replaced. So could there or should there be a case on the exact same thought process challenging the legacy admissions?
Yeah, so keep that same energy type case,
Right.
And
then that'll blow back into their faces because they want to keep their legacy admissions. They want to get their sons in. But if we use their same logic.
Yeah.
But is that an official policy of the schools, or are they just kind of doing that on the low?
That's a good question. I think it's an official policy. It's like with, if I remember right, George W. Bush, that whole thing, he used to joke about not being the greatest student, and he wasn't. But he got into, was it Yale, right? But because his dad.
Sure.
And he was able to go to Yale just fine.
I don't think I don't know if it's an official policy, but it's one of those poorly kept secrets, right? It's a practice that I think that everyone knows exists.
Right.
So,
but
and then I guess that would make it different.
Right? Would the school be arguing that they should be allowed to do it, or would they be arguing we're not doing that anyway? They deserve to get it. Yeah,
that's what I was gonna say. That would be difficult to argue against because the school say, well, that's not our policy.
Right. That's the thing, right? This case is about the policy. Now, what ends up actually happening might be a separate discussion, right? But this is about what
I mean, they could then they'd have to go through the admissions process and see who's been admitted and look at their credentials, how they got in. And see, well, that may not be your official policy, but look, this past 50, 60 years of your admissions, this is what you're practicing.
Right. Well, let's talk about that because that kind of ties to this next point. You said there's a two-pronged test here to meet strict scrutiny under the Equal Protection Clause when you're dealing with any kind of racial discrimination. So the court said the compelling government interest was not met. They said it was, commendable goals, but not a compelling interest. The second prong of that is whatever you're doing has to be narrowly tailored to meet that compelling interest, or has to be done in the least restrictive way. And the court said that the schools here failed to articulate a meaningful connection between the means and the goals. And they say the racial categories here are, quote, plainly overbroad. And in that case, they're saying there's no distinction between East and South Asian. They say they're arbitrary and undefined, and they use Hispanic as an example there. And they say they're under-inclusive because there's no category for Middle Eastern students. And so basically they're saying the policy isn't very fleshed out enough to meet that prong, to satisfy that prong of the test. They're saying it's all kind of vague and the school is basically just doing what it wants. And the court is saying the university's main response is trust us. And again, I put in my notes, was this just argued poorly? I mean, why wouldn't they come with all kinds of data to justify what they're doing? Why wouldn't they show why the classifications were set up the way they were? The court makes it sound like they just did whatever they want and they were just arrogant and wouldn't or didn't have real data to back up what they were doing.
Yeah, it does sound like it. I mean, sound like it could have been argued differently or better, like it was argued poorly. That's what it sounds like.
That's what it sounds like. Although I will be fair, when I get to the dissent, they seem to suggest something different. So it could be a case of the majority just, cherry picking the weaker points. But, I just had these questions like, why is the court even saying that? Why would the court put in the decision that the university's response is trust us? You would think the university would come with all kinds of numbers to back up these classifications.
They should. The universities themselves will have the data. There's plenty of data out there. I mean, there's data from the CDC about it, because race literally impacts health in this country. So they've done plenty of studies on it.
Right.
So there's plenty of data out there to really push the argument. So
explain why you have these classifications, what the data is supporting them, why you need them. Don't just say, trust us, this is how we do it because we want to do it. That's how the court made it sound anyway. That's what we're doing. So here's what I put down as a bad faith argument by the court. It says that the Equal Protection Clause mandates that race may never be used as a negative. The colleges say it isn't a negative, but the court says college admissions is inherently a zero-sum game where benefiting one race inherently comes at the expense of other races. Now, again, I see this as kind of the conservative way of thinking on the issue broadly. Helping someone else hurts me automatically, but I don't think that's the way we should be thinking about this. I think we should be thinking about it in terms of, if you help an underprivileged group, you're actually helping everyone, right? It's good for the country. It's good for all of us.
Exactly.
It's good for the college classes. I mean, makeup of the class, all the students there, not just the underrepresented minorities. Everyone in the class will have a better experience if it's a more diverse student body representative of the population of the country. I mean, this isn't just helping one person at someone else's expense. This should be thought of as being good for everyone.
Yeah, absolutely. I mean, it's kind of what's the old analogy. Like if you raise up something at the top, you're only benefiting people at the top. You raise up something at the bottom, it raises everybody up. Yep. So you look at a house. If you raise the roof up like 10 inches, like it's going to benefit tall people mainly. But if you raise the floor up 10 inches, everybody goes up 10 inches.
Exactly. Yep.
Rising tide lifts all ships.
Yeah, it's like that their argument is just the whole thing conservatives like to say about reverse racism, reverse discrimination, and all that. So it doesn't exist. Honestly, when you look at it from a power standpoint, from what race is, or from racism is, it's a power thing. And another things like to the point too is where a lot of these arguments, and even from the Supreme Court standpoint, is looking at, if we have these policies in place that negatively impact another group, you're automatically assuming Black students who are benefiting from affirmative action shouldn't be there. Because you don't know what their grades are. But the idea behind affirmative action is to make sure that African American students who actually do deserve to be there get a shot at being at Harvard, get a shot at being at these other all these different schools,
Yeah.
But then you have the other argument from conservatives who try and act like, they shouldn't be there if it's just because of the race, when it's not. It's never the case and that's how these college admissions programs go. With affirmative action, they do not admit literally because of race. These students deserve to be there. They performed academically to be there, but then they don't want to admit it. But honestly, the stance of trying to assume that a Black student is getting to a student only because of their race is honestly racist in itself, because you're automatically assuming that the student shouldn't be there because of their race, and they only got in because of it. Yeah,
right. And those students, I was gonna say, like you said, those students still have to perform academically. Right. It's not like they're going to be like, we're going to pick, we need some Black students. So we're going to get this one here who's a D student or a C student.
Right.
Like, no, the person that they're admitting still has to be academically inclined, or at least meet those standards. It's just making sure that this race-based discrimination doesn't exclude them from that shot.
And that comes up in a dissent also, which we'll get into, where they say basically before affirmative action, only the most elite students who are Black or Hispanic got into Harvard and schools like that. Most of them wouldn't, even if they deserved to, even if maybe the white classmates had grades that were comparable, they wouldn't get in. Only like the top, the top of the top ever got in. And so this leveled the playing field a little bit. So we'll get into that more. But I wanted to talk a little bit more about this whole zero-sum argument, because to me, it's a bad faith argument. They're saying that, mandates about race may never be used as a negative, but if you're going to use this whole zero-sum argument, it's always going to be a negative, right? Because you're saying that by definition, helping one group always comes at the expense of another group. And therefore, anything you do to help someone is going to hurt someone else, right? And so it's always going to be zero. If that's the way you think of it, it's a zero-sum game, right? I mean, that applies to, for example, MWBEs, minority women-owned business enterprises. I've worked a lot on that in Albany. Mm-hmm. If you're giving contracts, more contracts, city and state contracts to minority and women-owned businesses, if you have this whole zero-sum game mentality, then you're saying, well, that means it's coming at the expense of, white and Asian businesses, other businesses, men, male businesses. And then everything that you do is going to be a negative to someone else, if that's the way you think of this, right? And so then you wouldn't be able to do anything with race in mind.
That's why
the whole idea that race may never be used as a negative, only a positive, but that's an impossible standard to meet under this whole zero-sum game philosophy.
Right, and I think that's a key part of their decision is that it's going to open the door to a whole bunch of other lawsuits from conservatives to go after all these other programs, and then it's a regression. It's ultimately trying to MAGA folks, they say make America great again. We always say what when, and they're in their mind we know what they're talking about. We know they're talking about many decades ago, and
decisions about where this case takes us. Right?
Yeah, right. Exactly.
Yeah, and in that regard, I think we're seeing two things here. Like conservatives have been waiting for this to happen, right? So they're hitting the ground running with it. And Stephen Miller, who was former advisor to Trump when he was occupying the White House, I'm not going to call him by that title, when he was occupying the White House, Stephen Miller is the head of this legal organization called America's First Legal. And shortly after the decision came down, he sent a warning letter to over 200 law schools in the country saying that you better follow the Supreme Court decision or we're coming after you. Right. He put this letter out to over 200 colleges. So they've been waiting. They've been chomping at the bit. Like if you don't follow it to the letter, we're going to file suit against your university. And so that's one point. And then another point is that, and your point, KJ, about how this is opening up different things or how it's going to bring about this inequality is when California in 98 got rid of the affirmative action in college admissions, they saw a massive, very significant drop in college enrollment for African-American students and Hispanic students immediately. So that showed that it proved that these practices are still being done in the admission process. Now they've put some other things in place to try to mitigate that in the interim. And I think now they're starting to see some good results where it's getting to be a little bit more to that level to what it was when they did have affirmative action for the other things that they put in place. However, it's taken decades for that to happen. And so.
Well, here's where the Supreme Court is trying to leave some room, I guess, for race to still be a consideration in certain areas. And they kind of do this via footnote. But they're saying colleges can still use how race has affected a person's life in their admissions process, just not the consideration of race by itself. So you could still have students write essays on their experiences, things like that. And so if they're doing that, they could probably still do much of what they've been doing, just maybe calling it something a little bit different.
Right. And I think Harvard even came out and said, hey, there's this part in the report and we're going to do that, basically. Yeah. Which I do commend them for that. I do commend them for that. And it's just interesting, too, because I think for the 2027 class of Harvard graduates that were just admitted, 30% of the students admitted were actually Asian American. Only 15% were African American, and I think 12% were Latino American, or something like that. Latino. So it's nice to see that they'll look for ways to try and continue to have diversity on their campuses, because it's just definitely
right. And the other thing. Oh, go ahead.
I was going to say that's a good thing. However, that doesn't mean that all colleges are going to do that.
This is very true.
Especially, and this is an assumption, but let's look at red states.
Exactly.
That would have been, those politicians, those people in those positions in college boards that would have supported this repealing of affirmative action. Now they don't have to follow it. Now it's left up to their integrity to find a way to make some diversity. I don't think we're going to see it.
But what about private schools, though, too? And that was the distinction between Harvard and UNC. I mean, if you were a private school, you could do what you wanted, not to discriminate, but you didn't have to affirmatively have an affirmative action program, right?
Yeah. Especially with these other colleges, the names of them are kind of falling off my brain at the moment. But there's these Christian conservative colleges.
Right. Yeah.
What was the one for? What was it? The late Jerry Falwell founded. That's Liberty University, and there's one out in Texas too. I forgot, but there's, I don't even think they probably even have. I mean, who knows? They probably even have one in the first place.
Right.
But like colleges, institutions like that allows them to specifically not have it and not even care.
Right.
Yeah.
Right.
So, it's Jelon, you're right. It's like this. It's cool for some of these schools that are basically saying, yeah, we're devoted to continue to have diversity on campus, but there's other ones. These other ones are gonna be like, all right, bet we don't have to do this, and we didn't.
Right. The Supreme Court says we shouldn't be doing it.
Exactly.
Yeah. Now they've got exactly. Supreme Court says we can't do it. Like, what do you expect us to do?
Yeah, right.
So,
an interesting wrinkle in this. I just wanted to say they said that U.S. military service academies were not part of the ruling. They said it wasn't part of the case, but they acknowledged that there may be a distinct interest there to promote racial diversity. So why is it only in military academies but not other colleges?
They need minorities in the military.
Historically, that's how they fill out those X-rays, because they go to the people who are disenfranchised, they go to the people who are poor, and they say, listen, we got you a guaranteed paycheck, we got you a bunch of benefits, we got you a retirement plan. This is a way for you to go forward. We can pay for your school. This is a way for you to go forward, and we can use basically poor people and disenfranchised people to fill out our military, to put them in front of the bullets by a promise, with a promise.
Yeah, absolutely. But do you see how, from a constitutional perspective, this all kind of falls apart with that one footnote? But this doesn't make any sense now, right? If you should try to sell me this as your real analysis, but you're saying, but we're making an exception for military academies?
Right.
How does that make any sense?
I wonder how that point was brought up, or if it was, or if there was pushback on that. Like,
there was a footnote in the opinion, and they're saying that, that this wasn't what this case is about, right? So I think their excuse is, to challenge it, you would need someone to specifically challenge the admissions process in military schools. They're saying that might be a little bit of a different story. They're not really expanding on why that's a different story, though. Why is it so different?
Yeah, I mean, from the way of thinking, like you just pointed out, like that should have applied as well. But yeah, I can see they're going to make that distinction on it. And now I'm wondering, do you think strategically, because Harvard, you made the point, Harvard was a private school, UNC is a public school, that if strategically this was the point of having the two different lawsuits, is so that they could attack private and public.
Right, because exactly. If you want to challenge this for a public school, you need to bring up the 14th Amendment argument, the Equal Protection Clause, constitutional analysis. You have to do the civil rights argument for the private school. But the court just kind of merged these cases and used the same analysis. Really, you would use a similar type analysis here. There are differences between attacking something constitutionally and the Civil Rights Act, but the court decided to hear these cases together and decide these cases together, which really sends a message in its own, right? It's sending the message, basically, we're not making that distinction. We're not saying that the Equal Protection Clause fails, but the Civil Rights Act is good. We're saying that either way, you just can't do it, right?
And I think that was the outcome that they were looking for.
Yeah.
Right. You mentioned that we look back at the history of this. There have been quite a few affirmative action related cases that come before the Supreme Court. It's like the one that you mentioned in 2003. I remember that. And like even Bloom himself with the student fair admissions, group, they've brought multiple cases forward. I think one of them was where they were mainly representing a Caucasian woman, and I'm sure their website probably had Caucasian women on the website at the time. But now, of course, it's a strategy, and trying to pit people of color against each other. But it's just something that you look back at Bloom's history himself. He's the architect of all this. And it's not some conspiracy theory or anything like that. You literally go back and look up the cases and all that stuff. There's literally right there. And he's been doing it for decades. Yeah. And it's just now the most recent stuff has been through this organization he founded back in 2014. Now that's the new face for him of doing it. But he was doing it even before.
Yeah. So I want to talk about the Thomas concurrence briefly and then get into the dissents, which actually have bars. So I want to get into that a little bit. But the
Just imagine like someone in like the audience when they're reading the dissents. Bars,
bars, son.
My notes.
Imagine if it was like treated like a rap battle, right? And they're like, yo, hold up, let her cook. Like,
yeah, slow it down.
Hey, yo, I said.
I just rebutted you.
Right.
You heard that precedent? So the Thomas concurrence, he's really out on a limb. And we talked about that when it came to the abortion decision. So he agrees with the result, right? He voted obviously with the majority, but he's writing his own separate opinion because he's saying that he wants to go even further. He's not satisfied with saying that you can't have affirmative action in college admissions. He thinks that all affirmative action should be banned. This is what he's saying. He says Grutter was wrongly decided. That's the case from 2003, where they said you can't have a racial quota, but you can take race into consideration. He says he voted for that. He was a concurrence in that. So 20 years ago, he was on board with this idea that race can be a factor. And now he's saying that that case was wrongly decided. He wishes that could be outright overturned. We saw him doing this, like I said, with the abortion issue, right? He said, yeah, I agree with the reasoning, but it shouldn't only apply to abortion. It should apply to all these other things, birth control and what have you. Crazily, more conservative than the conservative majority, because even in that case, they were very careful to say, well, it's a special case. Our reasoning here only applies to abortion, right? Which, again, bit of a cop-out, sure. But at least I had that sanity, I guess, to say that we're not undoing everything that we rely on as rights based on this analysis. Thomas again is saying, no, hold up. We have this constitutional analysis. Why stop here? Let's just use it to ban all affirmative action, which I guess kind of what you were asking about, Jay, also, right? And I think KJ mentioned this as well. Like, this is not going to stop here. The door is open now, and Thomas is welcoming more challenges to more things, not just college admissions.
Yeah, absolutely. And I mean, of course, it's my opinion and speculation. I think it's a case of, Thomas has been in that position for decades now, and now he's forgotten where he came from. He's forgotten how he got there, and he's feeling entitled to the point where, like, yeah, I got here because I'm super freaking awesome, and not because I had help along the way. And that there was I sent it to you a couple of days ago, KJ, where there was this interview, and I think it was a documentary or something talking about Thomas, and they were looking at some of his previous colleagues and school classmates and whatnot, and they were going into the mind of Thomas as far as how he felt when he got admissions, because it was still a very discriminatory time where they were looked at as not deserving to be there. And so, some of this could play on his psyche on, how, he felt, now he's got the power to do something about it, or the power to calm his whatever. And so now he's doing something. I mean, of course, that's speculation, but, it comes down to the conservative majority on the panel now, and they can basically do what conservatives have been trying to do for decades.
Yeah, absolutely. So they've been trying, and I think, I'm a very big cynic when it comes to Clarence Thomas. I think that he has, over the years, got more and more and more comfortable in his conservatism of being able to express it. And even though these recent years, the Trump effect, I think he's even been impacted by it too. His wife was out there in support of January 6 folks. And so I think Thomas has gotten even more comfortable in his stances of conservatism. And I believe that, he wrote his own, I can forget the term for this ruling.
Concurrence.
Yes. And he wrote his own because he knows how it looks as far as him being a Black conservative on the court. And so he wanted to not, as he didn't, I don't think he wrote, of course, this is just pure speculation, but I don't think he wrote it as like a defense of himself by no means. He wanted to be an extremely strong voice because conservatives like to trot up, oh, well, this Black person is saying this or this Black person is saying that. And he wanted to be that voice. He wanted to be a very strong voice that allows for all these other lawsuits that'll come out and attack other programs that help progress in this country. And so I think that ultimately that was his big thing. And that's why he wanted to see if he could even go further on than what the actual, opinion decision.
And the majority knows that Thomas does this. He did it before. He just did it on the abortion case. So maybe at this point, if we're being cynical, maybe the majority would have gone farther, but they said, let's just let Thomas do it.
Let's let him do it.
Some face. We'll say, hey, you know what? We're kind of just being very narrow here, and we don't look so evil. Thomas is going to do that for us. He's going to play the villain.
Right.
I think partly in that way. And again, there's no, it's kind of my opinion, speculation or whatnot, but and partly in that way, it could be Thomas seeking approval to validate his position. Yeah. Right. Yeah. I listen, I'm voting against affirmative action. I'm voting against these things that help people get a seat at the table that I might have used, but I'm voting against it because I think people should be on their merits. And by doing that, it says I'm here on my merits only.
Right.
I didn't have any help. I earned this all myself. Right. He's validating his own position in that regard. And they say in some regard, hurt people. And I think there could be some of that plays into that. Of course, that can't be proven, but I think that some of that plays into that. And if we look at some of his classmates talking about Thomas, if we look at that and we take that at face value, I think that could play into it a little bit as well.
Right.
Yeah. No, it's wild. Thomas uses the phrase originalist constitutionalist to describe himself. And those are those real conservative buzzwords, right? He's trying to score points with that crowd.
Absolutely.
So, all right, let's get into the Sotomayor dissent, which was joined by Justices Kagan and Jackson. Mm-hmm. And like I said, dissents were read on the bench for the first time since 2019. This dissent, I think, was really well done. They talk about how the guarantee of equal protection can be enforced through race conscious means in a society that is not and has never been colorblind. The majority opinion really embodies the privilege of regarding race without that historical or societal context. Then it talks about the 14th Amendment, including the Equal Protection Clause, was passed in the wake of the Civil War. The majority fails to put that in perspective. The Civil Rights Act of 1866 was passed contemporaneously with the 14th Amendment. And so the 14th Amendment was really passed to try to undo some of the injustices caused by slavery coming out of the Civil Wars, trying to give Black Americans in particular equal rights. Now, yes, it's interpreted to mean equal rights apply to everyone, and that is true, but you have to put that historical context, I think, in mind when you're coming up with a decision like this. You don't just look at this in a vacuum. You have to look at what the history is and why we have these provisions of law, what they're meant to do, what they're meant to protect. And the majority opinion was really naive, probably intentionally so, but naive to all of that. And here's where I put bars for the first time in my notes. They talk about Brown v. Board of Education. So when we started this discussion, I pointed out how the majority right away goes to Brown v. Board of Education to make themselves seem like these crusaders on the issue, right? Like we're now coming out with our latest in a line of great civil rights decisions, Brown v. Board of Education, now this. And the dissent says, you don't know Brown v. Board of Education. It was Justice Thurgood Marshall, right, who was the lawyer who argued Brown v. Board of Education, and he rejected the framework that the majority is using. So if you're going to use Brown v. Board of Education, the lawyer who actually argued that case disagrees with everything you're saying about it.
Absolutely. And also the lawyer who went on to be on the Supreme Court.
Yeah, exactly. And he upheld all of that constitutional framework. He helped create.
Upheld all of that.
Yeah.
And once he passed, Clarence Thomas took a seat.
But the fact that Clarence Thomas is on the Supreme Court and Jackson is on the Supreme Court and Sotomayor is on the Supreme Court is evidence that we don't need those affirmative actions.
And that's exactly, I think it was Roberts, right? Didn't Roberts put that in his opinion when he was gutting the Voting Rights Act? The fact that we have a Black president is proof that we no longer need protections. Racism is done. Like that's what he was saying, right? He put that in the decision.
That's their argument.
It's always the argument is that when you have someone from a minority group get some sort of grand success, that racism doesn't exist because it ignores the majority of the others who don't have that.
Anecdotal. It's anecdotal. And it's just looking at things in a vacuum and being ignorant, probably deliberately so. I would look at the fact that
they're not just people aren't disenfranchised or disadvantaged. Look, you've got Oprah.
Right. Right. Exactly.
Billionaire. Women aren't disenfranchised. Oprah, she's a billionaire. She's a woman.
I would argue, this might be controversial, but I would argue the fact that Trump was president for 4 years proves that affirmative action is needed.
Yeah.
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 It shows racism is alive and well.
So. Absolutely. And thing about affirmative action too is studies have shown time and time again the biggest benefactor of affirmative action programs are actually white women.
White women, yeah.
Right.
Yeah, absolutely.
And that's something people like when I talk about MWBE, like people forget the W stands for women. I mean, people on the side of that.
Right. Yeah, absolutely. And I think Trump's presidency is also evidence that we need a mental health evaluation for candidates.
Right.
Well, okay. So the dissent also brings up that Grutter case, and they said student body diversity is a compelling state interest. And they mentioned academic freedom. I like that term, academic freedom, and the integrity of the institutions, of the colleges. They said having a diverse student body is good for everyone, including the white and Asian students, because everyone benefits from it, which is what I was saying before. I think that's really the way to frame the argument. And I don't know if it wasn't done effectively enough by the lawyers arguing this case on behalf of the schools. But when you talk about the compelling state interest, I think that's what you want to talk about, the student body diversity, the academic freedom, the integrity of the institutions. And again, that all goes to preventing and combating, mitigating against systemic racism and correcting those injustices. That's the compelling interest. How could you argue that's not a compelling interest?
I think
that's the way to frame it.
I think from our point of view, that sounds like a compelling interest. But from the opposing point of view, I don't think it sounds like a compelling interest to them. Right. It's not a way to sway their opinion, to say that, we need this mix and the variety of people in here to have this diversity, to have an enriching.
I hear that. But from a constitutional.
They don't give it.
No, I hear that. I agree with that. But politically so. But from a constitutional legal point of view, don't you think it's hard to argue that combating systemic racism is not a compelling state interest?
That's only if you agree that systemic racism exists. If your position is that it doesn't exist, then that point has no teeth.
But the court is not saying it doesn't exist. I mean, yes, they have said stupid things like, racism is pretty much over now. But in this case, you don't see any lies like that. There's no more racism, right? They're just saying that, a marketplace of ideas is kind of vague and it assumes that every person of a certain race thinks the same way. Maybe they're being very delicate in how they're attacking it, but it seems like they're saying that the compelling interest wasn't really stated here. They're not saying that combating racism is not a compelling interest. They're saying that wasn't the interest cited by the schools.
Yeah, I'm just saying that it's kind of a we can't point to the racism and for them to be like, yeah, okay, we agree that that's there. Right. For them to make this decision, I think it's easy to and probably viable to go ahead and presume that they're coming from this position that systemic racism doesn't exist in their mentality. For them to even make the decision because they're saying it's not necessary. Why would it be necessary? It's not here. Right. And so this idea that we think is paramount and super awesome to them is like, yeah, well, it's not necessary. It doesn't exist. It's not there. And so I think we can miss the point in an argument with them, especially if they've got the power in the majority. I think a stronger argument probably comes down to something that's more tangible, right? Like what KJ mentioned earlier, somehow economics. This is tangible. This is
right. But you still need to identify what the compelling interest is, and then you prove it with those tangible factors, right? With the proof, with the evidence, you have the data to back it up. But you still need to be able to show and articulate what that interest is. And the majority isn't saying that fighting racism is not a compelling interest. They're saying, it's commendable that you want a marketplace of ideas, but that's a very vague thing to say. So, I mean, they might be playing word games of their own here, but they're not outright shooting down this idea that racism is a thing and fighting it is compelling, right? They're not saying that.
But we know that side
kind of implies, right?
Right. We know that side. The decision implies that. And we also know that side often has that talking point, that mentality that this doesn't exist. Systemic doesn't exist. How? We had Barack Obama How we have Oprah, like this doesn't exist. Like it's just something
That's
you're
why
playing victim card.
That's why you got to come in with the facts, though, with the data,
Right.
showing it.
Yeah, something tangible. That's my point.
Yeah,
It has to be something tangible instead of saying that, well, it's not really tangible for us to go in and say, well, there is this benefit to having a people of all different races in the group, because it's not a really tangible thing that you can hold on to there to actually combat the argument that they're putting out. That's
my point. Yeah, no, that is my point, right? Like if you read the majority opinion, it's framed in such a way that makes it sound like the colleges went in and they were just like, yeah, it's better for us to have diversity in the school, and that was it. Just why? Trust us. How are you doing it? How are you coming up with this classification? Oh, just trust us. We're just doing it. That's how the majority opinion is written, to make them look bad. And I don't know how much they're actually doing that, how arrogant they really are. It makes them seem like they're arrogant and they just have this like idea in their heads, and it always kind of paints them as like these like elitist, arrogant people that you always hear about the conservatives talk about, right? Like these coastal elites. That's kind of how they frame it. But you would need to have all of the data showing why you have these classifications, showing why it's important. Why is a diverse body important? Why wouldn't you have a diverse student body without these programs? Like you have to show all of that.
Right.
So, but I like the dissent's framing of it, though, in terms of academic freedom and how you want to preserve the integrity of the very institutions, right? The institutions on the whole suffer, and that brings us all down if you don't have this academic freedom. And they make the point that, again, prior to these affirmative action programs, only the elite students who were Black and Hispanic were able to get into a school like Harvard. Most of the times, it was basically all white and Asian. That's a problem. That is to the detriment of our institutions, which is to the detriment of our whole country, right? I mean, so it's not just about one group versus another. I think it's about helping everyone and just kind of uplifting the integrity of our institutions.
What were you going to say, KJ?
No, I was saying that, actually, I forgot what the point I was about to say. but I was saying is that really does make me wonder again about exactly how this was argued.
Yeah.
In court. It really makes me wonder. And like what was presented? What was that compelling argument that they pushed forward? What was the data that they showed or lack thereof? Just really
I do want to go deeper into that. I will say that the dissent does say that the schools introduced dozens of fact witnesses, experts, and documentary evidence, whereas the petitioners did not. I think they just had two people testifying. And so, according to the dissent, the schools actually had more data on their side, but I don't know exactly what they did and how they argued it. For the majority to even be able to say what they said, it kind of made me a little confused, like, ooh, like, that sounds kind of odd. Right. But I also put in here, to play devil's advocate. So the dissent talks about how it's good for everyone to have a diverse student body. Of course, and I think Jay mentioned this point also, if you were one of the students who didn't get in, you probably wouldn't feel like it was good for everyone. You would feel like you were suffering.
Absolutely. Absolutely. And I think that's an important thing to bring in mind, that people have to remember, like, there's sometimes you just can't get in. Mm-hmm. And going and saying, look, I'm gonna file a lawsuit because now I'm didn't get into the school that I wanted to get into because of those people or whatever, again, it's a case of hurt people. Like sometimes it's just not possible, and we have to understand that as well. So yeah, I think it's a big issue there.
So I have another bar here from the dissent.
Bars.
Equality requires.
That sounds like a book. That sounds like some kind of a bars from the dissent.
Yeah, I could write like a Cliff Notes type thing on Supreme Court cases, but I'll have like the bars. So like the bars.
That would be kind of dope, like bars.
Right. Yeah.
So here's the quote: equality requires acknowledgement of inequality. The majority does not view equality through this lens, but presupposes we already have equality, and therefore doing anything to try to correct it is automatically wrong. That's what it is. Well, when we talk about equality, I think the majority and the dissent have different ideas of what equality means, right? The dissent, I think, correctly identifies that equality requires acknowledging inequalities. In other words, you have to put the entire context into consideration here. You can't look at this in a vacuum or in isolation as the majority is trying to do. They're not even acknowledging, and that's Jay's point I think you made from a few minutes ago, they're not even acknowledging the situation on the ground, right? They're not acknowledging the inequality that exists. And if you don't have that understanding, then it's hard to come to an agreement on what equality should mean if you're seeing the whole picture in two different ways.
Yeah, that's the big thing when it comes to conservatives in this country, that you hit the huge roadblock right there, is that they are not going to acknowledge inequality exists in this country. And since that's their stance, literally everything that is done to fight inequality is, in their view, wrong and reverse racism or reverse discrimination.
Right, exactly.
And
they're not seeing that without making these corrective efforts, you have a lot of inequality still. It persists. They think that the efforts themselves amount to inequality because I guess everything is just perfect in their minds.
Right, exactly. The good old days for them is what's in their mind.
Key words there. So the dissent goes on to make the point that the underrepresented minority students are more likely to live in poorer neighborhoods. Again, context missing from the majority. More likely to live in poorer neighborhoods and attend schools with fewer resources, thus not having the same opportunities afforded to others. They talk about the history, the troubled history of these schools when it comes to admissions. They even use the phrase bastion of white supremacy to refer to UNC. And the question now is what will happen? Will even qualified Black and Hispanic students be admitted? In the past, they had trouble getting in, even with good grades, and only the elite students made it in over the white students.
To my point about what affirmative action is for, it literally is there to get the minority students who absolutely deserve a chance to get in there. Because back prior, Black folks, Latino folks, Asian folks, people of color who had the grades that were good enough to get into these schools were not being admitted.
The whole evidence, the evidence is there. The whole reason like HBCUs exist is because of this. They wouldn't exist if that didn't happen. And I think we can look to, like we're talking about what happened, like what's going to be the result. I think we can look to what happened in California when they repealed affirmative action and say, this is probably what's coming. This is with, good reason. This is probably what's coming. There's going to be a significant drop.
So a good way to wrap up this discussion, the Jackson dissent has a great line also. More bars coming. The Jackson dissent, I think, really kind of summarizes this entire topic by saying, deeming race irrelevant in law does not make it so in life. No one benefits from ignorance.
Bars. Bars. Like, I think after she said that, she should have, like, right after she did that, she should have said time and then dropped it.
Yeah, totally. I mean, it's I was mentioned earlier about, like, periods of punishment in this country. You had slavery, absolute awful period of time. And we've made a little bit of progress there when the slaves were freed and you started to have the Reconstruction era. You got punishment there. Literally, Abraham Lincoln was assassinated for it. And then you had his successor come in there and stop Reconstruction. Andrew Johnson. Andrew Johnson, yes. Andrew Johnson came there, stopped it, ushered in the era of Jim Crow. And then, and so that was a period of punishment itself. And even there's so many different periods of time there that where you had periods of had progress in the period of punishment afterwards. Civil rights movement is an example of it. You have the Civil Rights Movement, you have the Civil Rights Act, and the Voting Rights Act go through. Nixon comes into office. And then what happens? Mass incarceration because they start their drug war, that targeted people who criticized the Vietnam War and targeted minorities who were very heavily involved in the Civil Rights Movement. And you start making progress. You fast forward some decades, you make progress under the Obama administration, same-sex marriage, healthcare, all that. And then right afterwards, you get someone elected in office and like Trump. And now, in my view, we're in a new period of punishment. And you see all
DeSantis' rise.
And DeSantis, exactly. He's coming, And so we're in what, especially if you look at it from a Supreme Court view, we are in a decades-long period of punishment because these folks aren't going anywhere for a very long time. And there's a built up from that. Thomas was appointed by HW. Yep. And then, Roberts and who else was appointed by George W. Mm-hmm. And then Trump appointed 3 others, and that was a slow go, but it worked. And you have even a part of what is that?
They're playing the long game.
They're playing the long game, and that's what the Republicans did. Even when they fought for decades against the Voting Rights Act, and they successfully did it. To gut it, where now they can make all these changes to the voting laws in the southern states, because at first they had to have federal approval to do that.
Right.
The students, they got that overturned by the Supreme Court. Voter ID laws came into play, even more of the gerrymandering, all that stuff. But they are playing a long game, and this is part of it.
And that's why voting for president is so important. And it's more than about who's going to be in office for the next 4 years. It's about potentially a generation or more of law and rights being affected because of the Supreme Court.
Yep. Supreme Court and the lower court judges. Trump appointed a ton of conservative judges that think like him, and then of course it's stacking the Supreme Court. That's a lifetime appointments here. We're talking, like you said, it's going to be decades, generations. Like you just get in, get out, but they've got influence for a long time. And I
think that's really the most important consideration you should have, in my opinion, when voting for president. What kind of Supreme Court do you want? What do you think our rights should be? How do you think the Constitution should be interpreted? Because that's the long-lasting effect of that. A lot of people go in, they think, I think it's time to shake things up. I think it's time for a change. And then 4 years later, they go both the other way. All right, but what about the lasting damage you did by enabling that for 4 years? So think about the long-term effects of this.
Right. Absolutely. I think conservatives and the far right are probably a little bit more better at that than progressives and liberals, because they'll play that long game. They'll play that idea. Let's stack the courts, because we know, on the surface they're looking at us because they're laughing at his way of speaking or whatever. But underneath they're like, let's get all these judges in here. Let's get this stuff, because we've got a long play. We're over here looking at this is funny, and they're like, we got you anyway.
Yeah, and then they're looking at also, it's like, we don't care the things he says about women. We don't care that he's assaulted women. We don't care that he is. You're right. Yeah,
that's what they say, right? I don't like the man. I like the policy.
You're right.
We don't care about all that. We don't care. You're canceling. You're upset. You're huffing. I don't care, because we got the judges' spots. We can overturn these things. We can do whatever we want to do. And I know this also brings up, a lot of people are talking now about extending the Supreme Court to combat some of this type of stuff. But I don't think that's a fix, because if it were 12 judges, or 13 judges, they would just stack it with 9. I think what has to be looked at here, and the people should have some sort of remedy to, is the corrupted nature of the Supreme Court as it is today. We've already seen Roberts and I forget what the other one have been taking, basically, we can assume bribes, and that the people should have a remedy to a corrupted Supreme Court.
Absolutely. You got Thomas, I think one of these conservative donors basically bought his mother's house or something like that's been paying for trips for him and his wife, stuff. And this is some major player in conservative politics and conservative policy making,
Right.
And I would not, I wouldn't, if this is the sort of thing that's going to happen, this could be just me being reactive, but if at some point we could somehow push a constitutional amendment through that would allow for term limits on the Supreme Court, in my view at the moment, I'd be supportive of that. Of course, that's me being reactive to things that's happening, but it makes
at least a way to hold them, accountable when it's become clear that they're not acting in the interest that they're supposed to be. And actually, I think it is worded in such a way that there is a way for that to happen. Because if I'm not mistaken, there has been one judge in Supreme Court history that was impeached, but it's only been enacted once. And I think the wording is as long as they're acting responsibly or something in that regard. I forget the exact wording, but there is.
happen in practice.
Yeah, it doesn't happen in practice, but I think there is a way out, so to speak, but it's never used and happened.
That also makes it harder to actually do because we have that way out on paper, right? So it's like, well, the system is already there, so I don't know what you guys want. It's like it makes it harder then to advocate for something if there's already a system there, it's just not being used.
Right.
Yep. So all right, we are running a bit long here because we had a very lengthy discussion on that case. So I want to kind of quickly go over the other things because we did have a poll, and I guess we want to put out the poll question for next week too, right?
Right.
So the poll for next week, I guess, will be on this. So why don't we do that first? So the poll question of the week is, do you agree with the recent Supreme Court decision ending affirmative action in college admissions?
I can imagine the responses on this, especially the conservatives, are going to come out the woodwork, I think. I want to say that, we did take this whole time basically talking about the affirmative action decision. And even though we had mentioned about the student loans and potentially the other case as well, but I'm okay if we, don't get as much time in the other ones, because what's really been kind of frustrating and unnerving me since these decisions came out is the talk has been largely about the student loans after that came out after the affirmative action. It's like there's more focus on the student loan issue than on the affirmative action, which to me is missing like the forest for the trees type of thing, right?
Yeah.
The affirmative action is the much bigger, much more broadly reaching decision than the student loan ones, but everyone's talking about their student loans, and it's just missing the point. And to me, is more evidence why affirmative action is needed, because people don't really seem to care as much about it.
I think it's also the 24/7 news cycle. Didn't the affirmative action one come out first?
Yeah, it came out first. Yeah.
That's kind of what happens. We even see that, like, something major in the news comes out that everyone should be talking about, and then some celebrity thing happens, and then that becomes a big story. It's like people sometimes don't pay attention to what they really should be.
But I think it's also people have student loans and they're like, well, I wanted my stuff forgiven.
Yeah, that's true too. It affects a lot of people too. Maybe more people, right? Because I think they said that the Biden student loan program was going to affect most people who had student loans. Like for me, it didn't even really make much of a difference. It wouldn't have made much of a difference for me. But I think most people.
Me neither. I paid off my student loans.
But we could talk about that briefly. Honestly, there wasn't much to say on this, in my opinion, from a constitutional perspective. It was much shorter. I mean, I say shorter, it was still 77 pages, but it wasn't the 200 plus pages of the other one. It really just goes into whether the executive branch, and really it's the Secretary of Education here, whether they have the authority to cancel student loans or to enact forgiveness, right? There was a law passed, and that's really what it comes down to. There was a law passed by Congress in this area. And so the constitutional argument becomes, do we have to then only go by what the law says because Congress acted on this already? Or how much room does the executive have to make changes to this? Their argument, the executive's argument, Biden's argument, is that they didn't make new law through the executive branch. They just modified or waived provisions of the law, which is allowed, right? The other side of it is, no, you already have a law on this and you can't just come up with your own provisions. You got to follow the law that's there. And so the court, perhaps predictably, came down on the side of Congress already having acted on this. And this was an improper attempt by the executive branch to legislate. So it's that separation of powers argument that you see over and over again. Of course, Trump, when he was president, had a ton of executive orders. Biden's doing some too. I think the more interesting discussion really here comes from a policy perspective. I mean, if it's got to be Congress, let it be Congress, but action should be taken on this, whoever it comes from.
Yeah, absolutely. The student loan thing is like, me, is like, if that went through, it would have wiped out the majority of what I have left. And I would have been very, very happy, so I've been feeling the sting of that, definitely. But it's and again, this also goes to the importance of voting in your local elections. And when I'm calling local, I'm calling even our House of Representatives. Yes, that's federal level, but you got to vote in those elections as well, because Congress controls the money. And if we're going to be in a position to be able to get these student loans forgiven, we got to elect folks in the House, and we got to elect folks in the Senate who are going to pass that legislation to do that. And Biden knows that it wasn't going to get passed in Congress, so he had to go this route, But it's on us. We got to get folks in there so we can get the number of votes in the Senate and the number of votes in the House that'll pass legislation that will get this done.
And sometimes the executive branch has to take bold action, even if they're not sure it will survive scrutiny, given the current makeup of the court.
Right.
If their hands are tied, like you said, if Congress isn't willing to do it, sometimes you see that bold action coming from the White House. Well, we're going to take a chance on this, and maybe it sticks, maybe it doesn't, but we're doing something, making the effort,
Right.
And now, from a political point of view, you can see the pushback. Like we said, people have been talking about this case for a long time. So it has brought the issue even more so, I think, to the forefront, and maybe it will play an even bigger role in the next election. And so maybe there is a valid strategy in doing that, even if it might get overturned.
Right.
Yeah.
No.
Before we wrap up, I just wanted to briefly say or bring up where, as far as the affirmative action fight, and it's been overturned with the Supreme Court and college admissions, what's the remedy from here, or what's the next steps in terms of this fight? Is this possible to reinstitute? Is there something that people can do? Is there something that the fight can be taken back up to try to bring it back in legally or actively, anything like that, any sort of remedy in that regard?
Well, it's tough now because the Supreme Court basically said this is what the Constitution, this is what the Civil Rights Act requires. It requires you to be neutral when it comes to the consideration of race in college admissions. There are ways that we're seeing, we talked about that they can still try to use it as a factor. Like, for example, saying, okay, we're not going to strictly talk about race, we're going to talk about your experiences as a Hispanic young man or as an African-American young lady or what have you. So you can do things like that in the schools, right? If you're really trying to get it overturned, if you're trying to get affirmative action implemented again, you have to have a better Supreme Court who's going to take on that issue again. And that means electing a president who has a different opinion as the previous president, maybe more in line with the current president. And if you have enough justices on the court, then these things can be revisited. I mean, that's where we are with it. I mean, the same thing applies to the abortion issue and these others that we're seeing. You have to get people on the court who have a different approach constitutionally and philosophically. Otherwise, the law is going to be that across the country. Once the Supreme Court decides it, all the lower courts are bound by that as well. If it's an area of federal, if it's a federal law, then every federal court has to abide by it. So it's where we are, Yeah,
and I think outside of a legal standpoint, a legal remedy, I think now it really does fall on different institutions to do their best to mitigate the negative impact of this ruling. I talked about HBCUs. I think alumni can do their best to stand up and donate to HBCUs more. I know there's a lot of folks in influence, not just Black celebrities, but folks who are well off who can donate to HBCUs. I think that's going to be very helpful, because I think there's going to be an influx of students going to HBCUs. These HBCUs are going to be needing new dorms, they're going to be needing new facilities, they're going to be needing renovations of their existing facilities, and that's going to come. There's going to be, I think there's going to be a new wave there, and that's just on the college level. It's like now, and in my mind, this impacts when it comes to kids right now. My kids are in school right now, and this impacts their schooling. I got to making sure that they get the best education that they can get, because now these affirmative action programs for college admissions aren't going to be in place, and because unfortunately the saying that has been around for decades in the African Americans community is that we have to be 10 times better, to get ahead, and so it's like that's something that weighs on me when I think about that for my own kids, and And so this, as far as like remedies outside of the legal standpoint, there's going to be a lot of people having to step up in different ways to support their local schools, to support their HBCUs, to support colleges who are doing a great job and continue to work hard to diversify their student body. But it's going to take that work and to help counteract, this mess.
And local governments, like to kind of bring it full circle, local governments like New York City, for example, need to be directing proper resources to these communities to make sure that people can get the chances that they need, because it is going to be tougher, and it already is tough. This makes it even tougher. Exactly. And so we need to make sure people are prepared for this world that we're finding ourselves in.
Exactly.
The next few years, we're going to see what the real results of this is. And I mean, we may need a green book for colleges at some point.
Yeah.
That data needs to be kept. Definitely.
Yeah, these colleges are practicing this. These colleges are striving for it. So let's put this together. So and that could impact them economically. Again, could go back to economics. Well, but we might, and that might need to be a thing at some point.
I agree. So to end off, I guess on a more positive note, we had the poll question from last week. Do you believe people who pled guilty to criminal offenses should have the opportunity to introduce new evidence to overturn their convictions? And this was based on a piece of legislation that passed through Albany. It was waiting for the governor's signature. I've got, 77% saying yes, 23% saying no. So I think that's encouraging that people think that it should be easier to challenge potentially wrongful convictions.
Yeah, and we had some responses on YouTube in that regard. People were saying yes. Some were saying yes because so many confessions are coerced. There needs to be recourse for that. Imagine if you didn't do it, but you can't prove it, and your lawyer tells you can't win with this evidence. Now you find out that you can do 5 years on a guilty plea or 20 years if found guilty. What are you going to choose? So people seem to be,
I just wish that there was some provision, like we talked about last week, some way for you to say, I'm going to take this deal that the prosecution is offering without admitting guilt, because that makes it more tricky when you admit before the court under oath that you committed the crime. And now later on you're saying, but I've got evidence to show I was innocent. It's like, wait a minute, didn't you just tell the court that you did it? So I wish there was a way for them to be like, yeah, I don't want to fight the case. I'm going to take the punishment, but I'm not admitting guilt.
Yeah.
Yeah. I mean, let's get this again, another full circle moment. So you think about Central Park 5, their confessions were coerced, and that was what happened with them.
Absolutely.
No.
Absolutely. And so I think it's good to see that there are a lot of people, at least in the ones who did answer, seem to lean towards yes, there should be more ability to introduce new evidence for people who even though they pled guilty. So I think that's a good thing.
Yeah. As we know, DNA evidence currently is allowed. So now they're trying to expand that beyond just DNA evidence to overturn a conviction. So that's what I said last week. If you're going to allow DNA evidence, why limit it to just that?
Right. So we like to give our guests the last word here to possibly to sum up what we've said, or whatever you like to say, what you think might be appropriate. We call it the bottom line. So, Kirshan Murphy, what is the bottom line?
The bottom line is, I think everybody needs to get fired up and go listen to Public Enemy's song "Fight the Power" and get hyped up, and let's do something about it, because that stuff's got to get done. And I think that's the energy we need to bring.
There you go. That takes it back to the music too. So all these things are full circle.
Exactly.
Full circle. Yeah. And where can we be found, Mike?
Oh, you put me on the spot. That was your thing. All right.
I did the bottom line thing this time. So, slide over.
Everywhere podcasts can be found. So that's Spotify, that's Apple Music, wherever you get your podcasts. Of course, we're on YouTube. You can watch the replays on YouTube, and we're on YouTube podcast now. I'm not entirely sure what that is, how that's different from a regular YouTube video, but we're there. You can check us out on social media. On Instagram, it's at Nuance Show. We put our polls up there. Also on my social media, on yours. So, check us out. We're around.
Absolutely. I think we had a pretty good conversation today. We didn't get to everything, but this is a pretty heavy topic. This is, this is a landmark decision. This is country changing. It's not a minor little thing. So Yeah, I think it was really good. Glad you came on. Figured you'd be the one to come in and contribute to this. I know Mike
Yes.
was
On this July 4th, no days off. Shout out to James Powers in the chat. So you guys aren't taking any days off.
right. Yeah, shout out to James in the chat. I see Vernay in the chat. Yeah, shout out to everyone. So
yes, as always, thank you for joining us. Thank you, Jay. Thank you, KJ. We've got work to do, and we will catch you next time.